have required me to, my children, to think about and see things that children should not have to see or think about. It's also been reported in the news that roughly 6 weeks ago, I was the victim of a swatting incident. At that point, one of my teenage sons, opened the door to go out with friends and saw in our street, it was full of police cars, who had responded to a false report of gunshots and raised voices in my home. I was very, very grateful that I had Supreme Court police outside my home because they were able to stop and meet with and explain to the county police that it had been a false alarm, and so the police did not actually attempt to enter our home. Many of us, me included, have received threatening anonymous deliveries designed to intimidate and harass us. They are often sent in the name of Judge Salas's son, who I think, as you mentioned in the beginning, Mr. Chairman, is deceased because he was killed by a disgruntled lawyer who showed up at Judge Salas's home intending to kill her, but her son, 20 years old at the time, opened the door and took the bullet instead. Her husband, standing behind, was seriously injured. So I think the message on these deliveries being sent in his name is clear. As Justice Kagan said, federal judges across the country, throughout the judiciary, including the Supreme Court, continue to do their jobs without fear or favor, but the threat level is really high.
Few institutions in the United States carry as much constitutional responsibility as the Supreme Court. Unlike Congress, whose members face election every 2 or 6 years, or the President, who remains accountable to voters every 4 years, Supreme Court justices are appointed for life. The framers intentionally designed the judiciary to be insulated from the shifting winds of public opinion, political pressure, and partisan passions. The court was meant to be the nation's impartial interpreter of the Constitution, guided by law rather than popularity, political expediency, or fear. This independence is not merely an administrative convenience. It is one of the central pillars supporting the American constitutional system. Alexander Hamilton famously argued in Federalist No. 78 that the judiciary would possess neither force nor will, but merely judgment. The court's authority depends almost entirely upon the public's confidence that its decisions are reached honestly, independently, and according to constitutional principles. Yet, the modern political climate presents new and unprecedented challenges to judicial independence. The United States has become increasingly polarized. Judicial decisions no longer generate only legal debate. They often provoke intense political reactions, nationwide demonstrations, online harassment, personal threats, and in some cases, acts of violence. Members of the judiciary now operate in an environment where controversial rulings can instantly trigger coordinated campaigns of outrage amplified through social media, 24 hours news coverage, and sophisticated digital technologies. Recent public discussions have highlighted growing concerns about the personal security of federal judges and Supreme Court justices. Increased security measures, threats against judges and their families, online intimidation, and attempts to expose personal information have all underscored the reality that judges are not immune from the broader political tensions affecting American society. These developments raise broader constitutional questions that deserve careful examination. If judges increasingly face intimidation, can the judiciary remain truly independent? How resilient are constitutional institutions when those entrusted with interpreting the law become targets themselves? What safeguards exist to ensure that judicial decision-making remains free from improper influence? These questions are not accusations directed at any individual justice. Nor do they suggest that any particular Supreme Court decision was influenced by threats or intimidation. There is no public evidence demonstrating that any justice has altered a judicial opinion because of personal safety concerns. Nevertheless, constitutional systems are strengthened not merely by addressing proven failures, but also by examining potential vulnerabilities before they become crises. So, in this video, we are going to explore those broader institutional questions. We are going to examine why judicial independence remains essential to constitutional government, how modern threats differ from those faced throughout most of American history, the theoretical risks posed by sustained intimidation, and the constitutional safeguards designed to preserve the integrity of the nation's highest court. Ultimately, this is not a video about any single case or any individual justice. It is a video about protecting one of America's most important democratic institutions. The American constitutional system rests upon an intentional separation of powers. The framers divided government authority among three independent branches: the legislative branch, the executive branch, and the judiciary. Each branch possesses distinct constitutional responsibilities, limiting the power of the others through a carefully constructed system of checks and balances. Within this framework, the judiciary occupies a unique position. Unlike elected officials, federal judges do not campaign for office, seek political endorsement, or appeal to voters for re-election. Their legitimacy derives not from democratic popularity, but from faithful interpretation of the Constitution and federal law. Recognizing this unique responsibility, the Constitution provides several important protections designed to preserve judicial independence. Federal judges receive life tenure during good behavior. Their salaries cannot be reduced while they remain in office. Their removal requires impeachment by the House of Representatives and conviction by the Senate, an intentionally difficult process designed to shield judges from political retaliation. These protections were revolutionary for their time. The framers understood that judges who feared losing their jobs after unpopular decisions could never function as genuine constitutional guardians. Instead, judges needed sufficient independence to rule according to law, even when doing so proved politically unpopular. Hamilton addressed this concern directly in Federalist No. 78, arguing that judicial independence serves not the interests of judges themselves, but the liberty of the people. He recognized that constitutional rights would become meaningless if judges lacked the courage or institutional protection necessary to enforce them against powerful political actors. Throughout American history, this principle has repeatedly been tested. Supreme Court decisions have often generated enormous political controversy. Cases involving slavery, segregation, civil rights, abortion, executive authority, religious liberty, and federalism have each produced passionate disagreement. Yet, regardless of one's political views, the legitimacy of those decisions ultimately depends upon public confidence that they were reached through legal reasoning rather than political intimidation. Once citizens begin believing judges decide cases because they fear retaliation rather than because they believe the law requires a particular outcome, the constitutional foundation supporting judicial authority begins to weaken. The court possesses no army. It commands no police force. Its authority depends almost entirely upon institutional credibility, and that credibility in turn depends upon independence. Judicial independence is often misunderstood. Many assume it exists primarily to protect judges, but in reality, it exists to protect the Constitution itself. Every constitutional democracy eventually encounters moments when popular opinion conflicts with constitutional principles. Sometimes, majorities demand policies that conflict with individual rights. Sometimes, elected officials seek powers beyond constitutional limits. Sometimes, intense political passions threaten to overwhelm legal restraint. During such moments, the judiciary serves as the nation's constitutional referee. Its responsibility is not to satisfy public opinion. Its responsibility is to determine what the Constitution permits. This function necessarily requires independence. A judge who fears political retaliation cannot effectively limit governmental power. A judge who worries about personal safety when issuing controversial decisions may face pressures unknown to previous generations. Although there is no evidence that today's Supreme Court justices decide cases based upon fear, constitutional scholars increasingly recognize that persistent threats against members of the judiciary represent institutional concerns worthy of serious discussion. The issue extends beyond physical violence. Modern intimidation can take many forms: online harassment, coordinated misinformation campaigns, publication of personal information, threats directed towards spouses or children, harassment at private residences, false emergency reports designed to trigger armed police responses, cyber attacks targeting personal communications, and attempts to damage professional reputations. Each incident may appear isolated. Collectively, however, they create an environment fundamentally different from the one envisioned by the Constitution's framers. The question is not whether judges should possess extraordinary courage. They should. The question is whether any constitutional system should expect judges to carry the burden of sustained intimidation without providing sufficient institutional protection. A judiciary consistently forced to focus upon personal security risks cannot devote its full attention to constitutional interpretation. Protecting judges ultimately protects the public's confidence. that judicial decisions remain independent. This principle benefits citizens, regardless of political affiliation. Every American, whether conservative, liberal, or independent, possesses an equal interest in ensuring that judges decide cases according to law rather than external pressure. For if intimidation ever becomes an effective means of influencing judicial behavior, every constitutional right becomes less secure.
My body, my choice. Stand up, fight back. Stand up, fight back.
For much of American history, judges worked in relative anonymity. Although controversial decisions certainly generated public debate, the daily lives of members of the judiciary remained largely private. News traveled slowly. Public criticism was limited by geography and traditional media, and direct threats against judges were comparatively rare. The 21st century has dramatically altered that landscape. Today's judges operate in an era of instantaneous communication, social media, artificial intelligence, digital surveillance, and unprecedented public visibility. A controversial decision issued in Washington can become the subject of millions of online comments within minutes. Public criticism, organized protests, and personal attacks can spread across the country almost instantly. Technology has transformed not only how judicial decisions are discussed, but also how judges themselves can become targets. Personal information that was once difficult to obtain can sometimes be discovered through publicly available records. Social media platforms make it easier for hostile individuals to organize campaigns of harassment. False information can spread rapidly, often reaching millions before corrections are issued. Cybersecurity threats now extend beyond government agencies to individual public officials and members of their families. Security professionals increasingly describe the threat environment facing judges as multidimensional. Physical violence remains one concern. Digital harassment represents another. Coordinated misinformation campaigns add a third. Foreign cyber capabilities introduce yet another layer of complexity. Even when these threats never materialize into actual violence, they create an atmosphere of uncertainty that previous generations of judges really experienced. This changing environment presents difficult questions for constitutional government. How should society protect judges without isolating them completely from the public they serve? How can transparency be maintained while ensuring personal security? How much protection is sufficient? These questions have become increasingly important as security officials continue evaluating new forms of risk associated with rapidly advancing technology. Artificial intelligence introduces additional challenge. Sophisticated voice cloning, fabricated videos, identity theft, automated misinformation campaigns, and increasingly convincing digital impersonation have expanded the range of potential threats that public officials may face. Whether directed at elected officials, judges, or ordinary citizens, these technologies demonstrate how rapidly the security landscape continues evolving. Now, none of these developments necessarily mean judges are unable to perform their constitutional duties. However, they illustrate how judicial security has become a serious institutional concern rather than merely a personal one. Protecting judges today involves much more than assigning security personnel. It requires safeguarding the independence of an entire constitutional branch of government. One of the most significant questions raised by modern security threats concern not physical protection alone, but human psychology. Every judge, regardless of experience, remains a human being. Judges have spouses, children, parents, friends, communities. Although they wear judicial robes inside the courtroom, they return home each evening to lives that resemble those of millions of other Americans. Constitutional theory often emphasizes judicial independence as though it exists solely as a legal doctrine. In reality, independence also depends upon psychological resilience. The legal profession expects judges to separate personal feelings from legal analysis. This expectation remains essential. Yet, psychologists have long recognized that persistent stress, uncertainty, and perceived threats can influence human decision-making in subtle ways. Importantly, influence does not necessarily require direct coercion. Behavioral science demonstrates that prolonged exposure to anxiety may affect attention, emotional regulation, and cognitive processing, even when individuals sincerely believe they remain entirely objective. This observation does not suggest that judges cannot remain impartial. Rather, it illustrates why constitutional systems should never allow circumstances to arise in which judges must routinely perform their duties under sustained intimidation. A judge should never have to wonder whether issuing a controversial opinion will place family members at greater risk. Likewise, judges should never fear that lawful constitutional decisions will result in harassment directed toward their homes, children, or personal lives. Institutional independence depends not only upon legal protections, but also upon ensuring that judges possess the practical freedom necessary to exercise independent judgment. The distinction matters. Courage is admirable. Institutional design should never require extraordinary courage simply to perform ordinary constitutional responsibilities. The judiciary functions best when judges can devote their attention entirely to legal reasoning rather than personal security concerns. This principle benefits every American, regardless of ideology. If intimidation ever became normalized as a political tactic, the long-term consequences would extend far beyond individual judges. It would fundamentally alter the constitutional environment within which judicial decision-making occurs. For this reason, threats against judges should concern citizens across the political spectrum, regardless of one's opinion regarding any particular court decision. Preserving an environment in which judges remain free from intimidation serves the interest of constitutional government itself. Although today's threat environment reflects modern technology, efforts to influence courts are hardly new. Throughout history, political leaders, interest groups, and private citizens have occasionally attempted to shape judicial outcomes through means extending beyond legal argument. Understanding this history provides important context for contemporary discussions about judicial independence. One of the earliest examples occurred during the administration of President Franklin D. Roosevelt. Following several Supreme Court decisions invalidating elements of the New Deal, Roosevelt proposed expanding the size of the Supreme Court, a proposal that became known as the Court Packing Plan. Although constitutional scholars continue debating its merits, critics argued that increasing the number of justices primarily to obtain favorable rulings threatened judicial independence by signaling that unpopular decisions might result in structural retaliation. The proposal ultimately failed, but the controversy highlighted enduring tensions between judicial independence and political accountability. Public criticism of Supreme Court decisions has likewise existed throughout American history. Decisions involving school desegregation, civil rights, abortion, executive authority, and religious liberty have all generated passionate public reactions. In many instances, judges have received criticism from both political parties, depending upon the issues involved. History demonstrates that disagreements with judicial decisions form a natural component of democratic government. The Constitution protects vigorous debate. Citizens possess every right to criticize judicial reasoning, advocate constitutional amendments, support legislative responses within constitutional limits, and encourage future judicial appointments reflecting different imperative philosophies. The line separating legitimate criticism from intimidation, however, remains critically important. Peaceful disagreement strengthens democracy. Threats of violence undermine it. Attempts to persuade judges through legal scholarship enrich constitutional debate, but attempts to frighten judges into changing decisions threaten the rule of law itself. This distinction explains why democratic societies invest significant resources protecting judicial independence. The legitimacy of constitutional government depends upon disputes being resolved through legal reasoning rather than fear. History consistently teaches that once intimidation becomes an accepted method of influencing public institutions, restoring confidence becomes extraordinarily difficult. For this reason, protecting the judiciary from unlawful threats should never be viewed as a partisan objective. It is a constitutional imperative. We have examined the importance of judicial independence and the evolving threat environment surrounding the judiciary. Those discussions naturally lead to a broader constitutional question. Not whether such a crisis currently exists, but what would happen if it ever did. It is important to begin with a clear distinction. There is no public evidence that any justice of the Supreme Court has changed a vote because of threats, intimidation, or concern for personal safety. The American constitutional system depends upon evaluating public officials based on evidence rather than speculation. Nevertheless, constitutional scholars often examine hypothetical situations precisely because doing so helps strengthen institutions before they encounter genuine crisis. One such hypothetical deserves thoughtful consideration. Imagine a future in which the security environment surrounding federal judges continues deteriorating. Judges routinely receive credible death threats. Their spouses are followed. Children require constant security. Homes become targets of repeated harassment. False emergency calls send heavily armed police officers to private residences. Cyber attacks become commonplace. Hostile actors publish personal information online. The purpose of these actions would not necessarily be physical violence alone. The objective could be psychological pressure. A campaign of intimidation need not convince a judge to rule a certain way. It may instead seek to create uncertainty, anxiety, distraction, or fear sufficient to influence the environment within which constitutional decisions are made. Again, this discussion remains entirely hypothetical, but constitutional governments require asking difficult questions before circumstances force immediate answers. If judges ever reached the point where they genuinely feared for the safety of their families whenever controversial cases appeared before them, would judicial independence remain fully intact? Could the public continue expressing complete confidence in constitutional decision-making? Will judges themselves recognize when personal security concerns began influencing subconscious thought? These questions have no simple answers. Behavioral science suggests that human beings often underestimate the subtle ways environmental pressures affect judgment. That observation applies to every profession. Judges, physicians, military commanders, corporate executives, and elected officials all remain subject to the same basic realities of human psychology. The constitutional challenge therefore becomes institutional rather than personal. The goal should never be expecting judges to possess superhuman emotional resilience. The goal should be ensuring they never need it. A healthy constitutional system minimizes opportunities for intimidation to become relevant in the first place. Democracy depends upon disagreement. Indeed, the United States was founded upon vigorous debate regarding governmental power, constitutional interpretation, and individual liberty. No public institution, including the Supreme Court, is immune from criticism. Citizens possess every right to disagree with judicial decisions. They may criticize opinions, write books, publish editorials, advocate constitutional amendments, support different judicial nominees, campaign for elected officials who promise different constitutional philosophies. All of these actions fall squarely within democratic self-government. The distinction becomes critically important, however, when disagreement crosses into intimidation. A constitutional democracy cannot function if judges fear retaliation for faithfully performing their duties. This principle protects judges regardless of ideology. A conservative judge deserves equal protection. A liberal judge deserves equal protection. An originalist deserves equal protection. A living constitutionalist deserves equal protection. Judicial independence belongs to the Constitution itself rather than to any particular political philosophy. Modern democracies therefore draw an important distinction between persuasion and coercion. Persuasion appeals to reason. Coercion appeals to fear. Persuasion strengthens constitutional dialogue. Coercion weakens constitutional institutions. Citizens should never hesitate to criticize judicial reasoning. Healthy constitutional debate requires robust disagreement, but disagreement must remain confined to lawful and peaceful methods. Threats, violence, harassment, stalking, or intimidation represent attacks not merely upon individual judges, but upon the constitutional order itself. The legitimacy of judicial authority depends upon public confidence that decisions result from legal reasoning rather than fear. When intimidation becomes normalized, even unsuccessful attempts can gradually erode public trust. Citizens begin asking questions that no constitutional democracy should encourage. Did the court decide this because the law required it, or because someone successfully frightened the people responsible for interpreting the law? Again, there is no evidence that such circumstances currently explain any Supreme Court decision. However, preserving public confidence requires ensuring those questions never become plausible. Unlike the executive branch, the Supreme Court commands no military. Unlike Congress, it controls no taxation. Unlike administrative agencies, it issues no regulations governing daily life. Its authority rests almost entirely upon legitimacy. People obey judicial decisions because they accept the court's constitutional role. This acceptance depends upon trust, not unanimous agreement, not universal approval. Trust. Citizens routinely disagree with Supreme Court opinions. Indeed, some of the court's most famous decisions remain controversial decades later. Disagreement does not undermine legitimacy. Suspicion about institutional integrity does. When Americans believe judges sincerely interpreted the Constitution, even if they strongly disagree with the outcome, the constitutional system remains stable. When citizens begin believing judicial decisions result from political pressure, intimidation, corruption, or hidden influence, confidence deteriorates rapidly. History demonstrates that public institutions often lose credibility gradually rather than suddenly. Confidence erodes through accumulated suspicion, repeated accusations, persistent polarization, and declining institutional trust. This phenomenon extends well beyond the judiciary. Congress experiences it. The presidency experiences it. News organizations experience it. Universities experience it. Courts are not immune. For that reason, preserving judicial independence serves a broader purpose than protecting individual judges. It protects institutional legitimacy. This legitimacy ultimately benefits every political movement. Today's majority may become tomorrow's minority. Every constitutional system eventually places unpopular causes before independent judges. The protections established today may one day defend citizens holding entirely different political beliefs. Judicial independence, therefore, represents one of the few constitutional principles benefiting everyone equally. It protects conservatives when conservative rights require judicial protection. It protects liberals when liberal rights require judicial protection. Most importantly, it protects the Constitution itself by ensuring legal disputes remain governed by law rather than political power. Every generation inherits the responsibility of preserving the institutions that sustain constitutional government. While the Constitution established the framework for an independent judiciary, it could not anticipate every challenge that future generations would face. The founders could not have foreseen cyber warfare, artificial intelligence, global informational campaigns, social media, or the speed at which political polarization would evolve in the digital age. Yet, the constitutional principle remains unchanged. Judges must remain free to decide cases according to law rather than fear. The question facing modern America is not whether judicial independence should be protected. The answer to that question is obvious. The real question is whether the mechanisms designed to protect judicial independence remains adequate for today's threat environment. Modern judicial security must extend beyond courthouse security. It now includes protecting judges' homes, their families, their communications, their digital identities, their private information, their transportation, their online presence, their cybersecurity, their ability to deliberate without intimidation. This represents a significant evolution in what judicial security means. Historically, protecting judges largely meant protecting the courtroom. Today, the courtroom is often the safest place a judge visits. Threats increasingly originate outside the courthouse. They arrive through anonymous emails, encrypted messaging applications, cyber attacks, online harassment campaigns, false emergency reports, deepfake technology, foreign disinformation operations. These realities require institutional adaptation. Security should never become a partisan issue. Whether one agrees with a Supreme Court opinion or strongly opposes it, every American benefits when judges remain insulated from unlawful pressure. The independent judiciary serves conservatives. It serves liberals. It serves independents. Most importantly, it serves future generations who may someday depend upon constitutional protections during moments of national disagreement. Strengthening judicial security, therefore, should not be viewed as protecting individuals alone. It represents an investment in constitutional stability, like protecting elections, safeguarding military installations, or securing critical infrastructure. Protecting the judiciary helps preserve confidence in one of the nation's foundational institutions. One of the most difficult constitutional questions concerns the ethical responsibilities of judges who believe they may no longer be capable of exercising completely independent judgment. The American legal system already recognizes circumstances requiring judicial recusal. Judges routinely step aside when financial conflicts exist, when close personal relationships create potential bias, when previous involvement in litigation raises concerns regarding impartiality. These standards exist because justices must not only be fair, they must appear fair. Public confidence depends upon both actual impartiality and the appearance of impartiality. This raises an important hypothetical question. Suppose a judge genuinely concluded that extraordinary external pressure had become so overwhelming that maintaining complete independence was no longer possible. What ethical obligation would follow? There is no simple constitutional answer. Many would argue that a judge's duty is to continue serving despite enormous pressure. History contains numerous examples of courageous judges who issued unpopular decisions while facing public criticism, political hostility, and even personal danger. Their perseverance strengthened judicial independence. Others might argue that if a judge sincerely believed fear had impaired objective judgment, continuing to participate in cases could ultimately cause greater institutional harm than temporarily stepping aside. The central issue is not weakness, it is integrity. Every judge takes an oath to support and defend the Constitution. That oath requires faithful application of the law, independent of personal preference or external influence. If a judge honestly concluded that independent judgment had become impossible, constitutional ethics would require confronting that reality honestly. Importantly, however, this hypothetical should never be misunderstood. There is no public evidence that any Supreme Court justice has reached such a conclusion, nor is there evidence that any justice has allowed intimidation to influence constitutional interpretation. The broader lesson instead concerns institutional preparedness. America should strive to ensure judges never confront such circumstances. Rather than expecting extraordinary personal sacrifice indefinitely, constitutional government should provide sufficient institutional support that judges remain free to perform their responsibilities without fear. The burden of protecting judicial independence belongs not only to judges, it belongs to the nation. Public confidence in the judiciary depends upon maintaining a careful balance. The court must remain independent enough to resist political pressure, yet it must also remain accountable to constitutional principles rather than becoming isolated from public life. This balance becomes increasingly delicate during periods of intense polarization. Calls for reform frequently arise after controversial decisions. Some advocate expanding the court, others propose term limits. Still, others recommend ethics reforms, increased transparency, or procedural changes. Reasonable people disagree regarding these proposals. What deserves broader agreement, however, is the principle that reforms should strengthen judicial independence rather than weaken it. Measures designed primarily to punish unpopular decision risk-taking, precisely the type of political pressure judicial independence was intended to prevent. Likewise, efforts to intimidate judges through harassment, violence, or threats undermine constitutional government regardless of political motivation. A healthy democracy distinguishes between institutional reform and institutional retaliation. One seeks improvement, the other seeks influence. The difference matters enormously. History demonstrates that constitutional institutions remain strongest when reforms emerge through careful deliberation rather than immediate emotional reactions to controversial rulings. Patience often protects constitutional stability. Political passion, while understandable, should not become the primary architect of institutional change. The judiciary ultimately derives its legitimacy from fidelity to law rather than popularity. Protecting that principle requires restraint from political leaders, civic organizations, media institutions, and ordinary citizens alike. The Constitution entrusts judges with immense authority. Citizens bear an equally important responsibility to preserve the environment within which the authority may be exercised independently. Judicial independence is often discussed as though it was solely the responsibility of judges themselves. In reality, constitutional government imposes responsibilities upon citizens as well. Every democracy depends upon public habits, respect for lawful disagreement, commitment to peaceful political participation, acceptance that constitutional disputes should be resolved through legal institutions rather than intimidation. These civic virtues become especially important during periods of deep national division. Americans increasingly consume different media, different political narratives, different interpretations of constitutional events. Disagreement itself poses no danger. The danger arises when fellow citizens cease viewing one another as participants in a shared constitutional experiment. Courts inevitably issue decisions some Americans celebrate while others condemn. That pattern has existed since the Republic's earliest years. The health of constitutional government depends not upon unanimous agreement with judicial outcomes, but upon widespread acceptance that disagreements should remain peaceful and lawful. Citizens therefore possess significant influence over the long-term health of judicial independence. Political rhetoric matters. Public discourse matters. Respect for constitutional processes matters. Responsible criticism strengthens democracy. Threat weakens it. Constructive debate encourages institutional improvement. Violence and intimidation erode institutional legitimacy. The future of judicial independence ultimately depends not only upon judges but upon the civic culture surrounding them. A constitutional republic survives because citizens voluntarily choose constitutional methods over coercive ones. That choice must be renewed by every generation. History offers a valuable reminder that the independence of the judiciary is never permanently secured. Every constitutional democracy must continually reinforce the institutions that preserve the rule of law. Around the world, nations have experienced periods in which courts came under intense political pressure. Sometimes that pressure originated from elected governments seeking greater control over the judiciary. In other instances, it came from revolutionary movements, extremist organizations, organized crime, or periods of severe political instability. The methods have varied. Some governments attempted to weaken courts by removing judges or expanding judicial appointments for political purposes. Others reduced judicial authority through legislation. Still, others allowed intimidation, violence, or public harassment to become normalized without adequate institutional response. Although these situations differ significantly from the constitutional structure of the United States, they demonstrate an important principle. Judicial independence is not self-executing. It survives only when governments, public officials, civic institutions, and ordinary citizens actively defend it. Healthy constitutional systems share several characteristics. First, judges are protected from unlawful intimidation. Second, disagreement with judges' decisions remain vigorous but peaceful. Third, constitutional reforms occur through lawful democratic processes rather than through coercion. Finally, public confidence is strengthened by transparency, accountability, and respect for the separation of powers. The United States has benefited from more than 2 centuries of constitutional continuity because these principles have generally remained stronger than partisan disagreement. That tradition deserves careful preservation. The United States is living through one of the most politically polarized periods in modern history. Americans disagree over immigration, federal power, election laws, religious liberty, gun rights, abortion, administrative authority, economic policy, national security, and the role of the federal government itself. Increasingly, many of these disputes ultimately arrive before the Supreme Court. As political divisions deepen, public expectations of the judiciary also change. Some citizens expect the court to advance preferred policy outcomes. Others expect it to restrain government. Still, others evaluate judicial legitimacy almost entirely by whether they agree with a particular decision. These trends create significant institutional challenges. A judiciary cannot function effectively if its legitimacy depends solely upon producing politically satisfying outcomes. The Supreme Court exists to interpret the Constitution, not to guarantee that every political movement achieves its objectives. That principle sometimes disappoints conservatives. It sometimes disappoints liberals. It sometimes disappoints everyone simultaneously. Such disappointment is not evidence that constitutional government has failed. It is often evidence that constitutional limits remain meaningful. At the same time, public confidence requires more than simply asserting judicial independence. Courts benefit when they explain their reasoning clearly, maintain high ethical standards, avoid unnecessary political commentary, and conduct themselves in ways that reinforce institutional integrity. Trust grows when citizens believe judges are acting in good faith, even when they strongly disagree with the conclusions. Polarization therefore places responsibilities upon everyone. Political leaders should criticize judicial reasoning without encouraging hostility toward judges. Media organizations should report accurately while avoiding sensationalism. Citizens should engage passionately while respecting constitutional boundaries. Judges should continue deciding cases according to law rather than political popularity. These reciprocal responsibilities help preserve the constitutional balance envisioned by the framers. Every generation inherits institutions it did not create. The Constitution, Congress, the Presidency, the Supreme Court. These institutions survive not because they are perfect, but because successive generations choose to preserve them while improving them through lawful constitutional means. Judicial independence represents one of the most remarkable features of the American constitutional system. The framers understood that liberty requires judges capable of deciding difficult cases without fearing political retaliation. For more than 2 centuries, that principle has helped maintain the separation of powers that distinguishes constitutional government from government driven solely by temporary political majorities. Today's challenges differ from those faced in earlier eras. Technology has transformed communication. Political disagreement has intensified. Public officials increasingly face threats unimaginable to earlier generations. These realities require thoughtful adaptation. Protecting judges no longer means merely protecting courthouses. It means protecting the constitutional environment within which independent judgment can flourish. This video has explored hypothetical institutional risks rather than making allegations about any particular justice or any specific Supreme Court decision. There is no public evidence that members of the Supreme Court have altered constitutional decisions because of threats or intimidation. Responsible constitutional discussion requires recognizing that distinction. Nevertheless, examining hypothetical vulnerabilities remain worthwhile. Strong institutions do not wait for crisis before evaluating potential weaknesses. They strengthen themselves in advance. Whether one approaches constitutional interpretation from an originalist perspective, a textualist perspective, a living constitutionalist perspective, or another judicial philosophy altogether, one principle should unite Americans across ideological divisions. Judges must remain free to decide cases according to their honest interpretation of the law, not according to threats, not according to intimidation, not according to fear, not according to political popularity, but only according to the Constitution and the laws of the United States. That principle protects every American. Today's majority may become tomorrow's minority. Today's celebrated judicial decision may become tomorrow's controversial precedent. Constitutional protections endure precisely because they apply regardless of changing political fortunes. Ultimately, preserving judicial independence is not merely the responsibility of judges. It belongs to legislators who fund security. It belongs to law enforcement officers who investigate threats. It belongs to civic leaders who encourage peaceful disagreement. It belongs to journalists who report responsibly. It belongs to educators who teach constitutional principles. And it belongs to citizens who choose debate over intimidation, persuasion over coercion, and constitutional processes over political violence. The strength of the Supreme Court has never depended upon unanimous agreement with its decisions. It has depended upon widespread confidence that those decisions were reached honestly, independently, and according to law. Protecting that confidence may be one of the most important constitutional responsibilities of our time. For if judicial independence is preserved, the Constitution remains capable of protecting the liberties of future generations. If judicial independence is ever lost, the consequences would extend far beyond any single case or any single court. They would reach to the very foundation of the American constitutional experiment. The health of a constitutional republic is measured not by the absence of controversy, but by the resilience of its institutions in the face of controversy. The Supreme Court will continue to issue decisions that divide the nation. Citizens will continue to debate those decisions passionately. Such disagreement is a feature of democracy, not a flaw. The enduring challenge is ensuring that the institution remains capable of deciding those cases independently, with integrity and free from unlawful influence. That is a responsibility shared by every generation, and one that will determine whether the rule of law remains one of America's defining strengths in the decades to come.